welcome and greetings, everyone. So I'm Dr. Costantino Grasso. I'm an associate professor in business law at Manchester Law School and the editor-in-chief of the Corporate Crime Observatory. I'm delighted to welcome you to our event, From Revelation to Justice, the Socio-Legal Dynamics of Disclosures. This International Roundtable is a collaborative initiative between Manchester Law School and the Corporate Crime Observatory. It is a hybrid event, and we are thrilled to have both in-person attendees here in the beautiful moot court room at Manchester Law School, including experts, colleagues, and my LLM students from the corporate governance course, as well as participants joining us via Zoom. So I'm enabling now the caption. Okay. So today's event is part of a research project that, together with other colleagues from the CCO, I have undertaken over the past 5 years. It began with a focus on whistleblowing, and it has demonstrated that in areas such as preventing criminal activities, addressing responsible corporate behavior, and safeguard democratic principles, disclosures made by courageous members of civil society who expose hidden illegal activities or unethical practices are essential for the pursuit of justice. This disclosure, from what I refer to as the ecosystem of truth, I formally adopted this term, which has been occasionally appeared in journalistic context, because I really believe that it captures the need for a comprehensive approach to this phenomenon and its significant socio-cultural and legal implication. So the ecosystem of truth refers to the complex interconnections between investigative journalism, whistleblowing leaks, as well as their interactions with public and private actors. It represents a dynamic network of intricate relationships that are crucial to the democratic process and the pursuit of justice, where truth is uncovered and addressed through the coordinated efforts of multiple actors. The ecosystem of truth and its dynamics, which remain underexplored and on the fringe of academic debate, demand our attention, not only to better understand, of course, the phenomenon itself, but also because I believe that as academics, it's our duty to support those who, like investigative journalists, whistleblowers, put their personal life at risk and also their professional life safety at risk to speak the truth. They play a vital role in our society, a role brilliantly encapsulated by the Washington Post slogan, "Democracy dies in darkness." Our exploration of the ecosystem of truth began with a roundtable we organized with the judicial schools of Italy and Moldova last May, entitled "From Leaks to Justice, Challenges, Opportunities from the Judiciary in the Age of Disclosure." In addition to today's event, I'm pleased to announce that we have also scheduled a paper session on these topics, the ecosystem of truth, how investigative journalism, whistleblowing leaks safeguard democracy, for the upcoming annual meeting of the Law and Society Association in Chicago at the end of May 2025. Furthermore, along with over 20 partners from Europe and the United States, we are preparing a proposal for the European Horizon Project. Our initiative is called Crime Investigation Transparency Enhancement. It aims at strengthening the initiative capabilities of EU law enforcement by developing solutions for more effectively integrating disclosures into official investigations. So as you can see, we have a well-defined research path ahead that will keep us quite engaged in the coming years. I won't take any more time away from our standing panelists, and it's a pleasure to welcome them, both in person and online, and we look forward to learning from each of you. I would also like to sincerely thank everyone in the audience for taking time to join us today, whether you are in person here or participating remotely. Before we get started, I'd like to share some details about proceedings. So we have 8 panelists, each of whom will deliver a 15-minute presentation, that's the limit, on select topics focused on the interconnection between the main players in the ecosystem of truth and the administration of justice. After the presentation, we will have 10-15 minutes of joint question and answer time. As I said to you, for our online audience, the chat function is disabled to prevent disruption, so please use the Zoom question and answer time interface to submit your questions, share opinions, or suggest relevant cases or stories. We are eager to hear from your thoughts and learn from your experiences. I'm now honored to introduce our first speaker. So our first speaker is Professor Annalisa Mangiaracina. So Annalisa Mangiaracina is Professor of Criminal Procedural Law at the University of Palermo and visiting scholar here at Manchester Law School. She teaches courses on criminal procedural law, European International and Comparative Criminal Procedure, Judicial Cooperation, Security, and Migrants' Rights. She's the author of 2 books and several articles and collective works on various topics related to national, European, and international criminal procedural law. So our presentation today is entitled From Disclosure to Action, Exploring the Impact of Whistleblowing on Criminal Investigation in Italy. So Annalisa, please come here, the floor is yours.
Okay. Good afternoon. First of all, I would like to thank Professor Costantino Grasso for kindly inviting me to this roundtable events on relevant topics under the debate also in Italy. My presentation is aimed at discussing the impact of the new Italian legislation on whistleblowing on criminal investigation, especially with regard to private entities. Italy okay, can you see the screen? Okay. Oh, sorry. Okay. Italy has implemented a directive on whistleblowing in March 2023. And this regard, it is also relevant in the context of legislative framework, legislative decree concerning the administrative liability of legal person who has been touched also by the reform. And as well as guidelines adopted by the Italian National Authority against corruption are an important source of law at this regard, and notwithstanding being soft law. But as relevant to understand some points regarding the interpretation of the content of the Italian legislative decree. What is new? It is evident from the perspective of the directive as implemented by Italy that there is a preference for an internal reporting channel. According to the European legislator, there should be a graduation in the channel used to disclosure of wrongdoing inside legal entities. But according to the new rules, legal entities working in the private sector are under the obligation to adopt internal reporting channel. These channels must set up after consultation with the trade union representative and be designed in such a way to secure also through the use of encryption systems the confidentiality of the identity, not only of the whistleblower, but also of other people who are involved in the report, as well as the confidentiality of the content of the report. And this is very important that according to the new law, this channel should be managed internally or by a designated person or department, or externally by third parties, including law firms. This is a choice for the legal entities that has specific consequences with regard to the law client privilege. At this regard, the International National Authority Against Corruption has suggested to accord this kind of, to assign the management of the channel to an internal audit to the supervisory body, or as an alternative to ethic committee. It is also to underline that for private entities that adopt a compliance model, which under national law are not mandatory for legal entities, these reporting channels are to be mentioned in the model itself. But in the graduation of the channels of reporting, why there is this preference for internal reporting channel? And the idea behind, as written in the directive, I'm reading textually, is to foster a culture of good communication and corporate social responsibility in organizations, whereby reporting persons are considered to significantly contribute to self-correction and excellence within the organization. And this is true especially for private entities. Inquiries conducted by or on behalf of organization are deemed as an integral part of the successful defense of corporations against charges of misconduct, as well as an important board management tool for assessing questionable practice. And the internal investigation, as demonstrated by a recent judgment adopted by Tribunal of Milan, can be a way to escape for a criminal responsibility for private entities. At this regard, there are different stages to be followed. After the internal reporting, it is necessary to submit the notice of receipt of the report by the competent authority. And then it is necessary the designation of an impartial person. And I would like to underline the word impartial person. The next stage is the diligent follow-up. It means action taken to assess the accuracy of the allegation made in the report by the whistleblower. And this regard, follow-up could include, for instance, the closure of the procedure because there is not sufficient evidence, or, and this is more important, the launch of an internal inquiry, and possibly its finding and any measures taken to address the issue. The end of the stage is represented by the feedback. There is a communication since the beginning of the disclosure and between the competent authority in the legal entity and the whistleblower, who should be informed step by step, which is the consequence of the new law. The consequence of the new law is the significance of internal investigation will grow considerably. For the effective detection and prevention of breach of union law, it is vital that relevant information reach swiftly those closest to the source of the problem, most able to investigate and with powers to remedy it, is again the express content of the directive. This kind of investigation, according to some scholars, are called as reliance and duty investigations. But are there any provision in the directive as well as in the legislative decree that explain what kind of investigation should be performed in this regard? The answer is no, except for one provision, according to which whistleblower can be heard or under his request is heard in written proceeding through the gathering of written observations and documents. But it is well known that at this stage there are other kind of evidence that can be gathered in most cases. These evidence are represented by the collection of data saved on electronic data storage media, video monitor recordings, and the questioning of employees, witnesses, or persons who are involved in the irregularities. The main problem is that the new law, in a sort of continuance with the previous legislations, has not specified the mean of obtaining this kind of evidence. So, at this regard, there are some questions. Who perform this kind of investigations. As we said at the beginning, there are two options, people from the corporations or an independent external expert. There are both advantages and disadvantages because in the first case, people from the corporation will know the dynamic of the corporation or the organization, but maybe don't have the necessary knowledge, but especially don't have the necessary impartiality that is requested by the directive itself. And more important, if we consider the appointing of in-house counsel, there is a problem concerning the lawyer-client privilege that we miss. And this kind of investigation can be used in criminal proceedings. And also in this case, the answer depends on the answer that we gave to the first one who performed this kind of investigations. Because internal investigations performed by in-house counsel maybe can be used as evidentiary at the trial. Or should they performed by an external counsel under the so-called umbrella of defense investigations can have a different status, can be fully used within the criminal proceedings. But the next important step is how to protect the whistleblower. The protection of confidentiality, according to the new law, is not different by it was before the approval of the new legislative decree. I mean that the identity of the whistleblower may not reveal, except with the express consent of the whistleblower. And the prohibition refers not only to the name, but also to the other elements of the reports to which the identification can be deduced. But the right to privacy is not absolutely far-reaching because it depends by the evolution of these internal proceedings. Because should it close with the opening of a criminal investigation, the protection of whistleblowing, as it was in the past, is limited to the stage of preliminary investigations. What does it mean? It means that the right to privacy cannot prevail on the rights of defense of the accused, and is correct in our system. So as a consequence, the whistleblower who file a report may become a witness, losing the right to anonymity, has the right to appear in front of the court. But reading the directive, there is a point where the whistleblower is defined as a person who should have a special status, the status of vulnerable person. Is not the category of vulnerability that normally we consider in our system. When I speak to my students about vulnerability, I think about elderly people, women, child. But the whistleblower is a person that is in a position of economic dependence, especially in the context of private legal entities. So the lack of a specific protection, unless we consider the possibility for the judge to, by a special assessment that normally is conducted case by case by the Italian judge, to consider the person as vulnerable, it doesn't have the recognition of special guarantees. I mean, the possibility to be heard during the special hearing in the course of the preliminary hearing, the so-called in Italy incidente probatorio. And the question is, at this regard, could this be a deterrent for the whistleblower? I'm going to the conclusion because time is running. So I will try to give an answer to my final question. I have more questions than answers, unfortunately. Has the new law an added value in this context? Yes, sure, it is a comprehensive instrument that is applicable to public and private entities, and it is a duty for private entities that respond to certain conditions to implement these internal channels. But the directive still has the directive, sorry, and the legislative degree, more than directive, has adopted a sort of minimalist approach. Especially with regard to private entities, as I said at the beginning, most because the investigations that should be performed after the disclosure are not regulated by the law. And this could create some problem for the protection of whistleblowing. What kind of guarantees should be recognized to this person where is aired by the audit or the ethical committee, depending by the choice that the society will decide to adopt. And it should be exactly identified the body that analyzes the information, the composition, and the rule to be followed. I think that I have just finished that there are new duties on entities, especially on entities that adopt compliance model, and new duties also that has an impact from an economic perspective on this kind of entities. But there are not new advantages by the implementations of this kind of internal channels. Thank you for your attention.
Thank you very much. Okay, so thank you very much. Let me stop sharing the screen. This was a very interesting presentation. Just to comment, I don't want to waste a lot of time, but it was very good, and I really like when you focus your attention on the absence of anonymity rights for whistleblowers then when they become witness in trial. I think this is very important. This is exactly where we are looking, we are researching too. I think when they conceived the directive, they didn't look at the transposition from this into concrete investigation. They were not thinking what happens to the procedural rules, and that's why we have to work in this area. So because they are disclosure, and then what happens? You know, then what? That's very interesting. So the second thing is minimalist approach. I mean, it's a bit sad, honestly, when I read about the bill in Italy during the implementation process, they really wanted to expand the whistleblowing protection to EU law and Italian law violations. And then the final bill was no, only EU law violation, the minimalist approach. Why government are so reluctant to protect whistleblowers? I mean, this is so bad. They had the chance to do it properly, and they didn't do that. That's a big question, but you know, we can debate it a lot. So now, like, if David Decide is with us, hi David. So we can have you as a second speaker. So we try to also alternate online and in-person speakers. So let me introduce David. So David Side. So David is Senior Counsel at Government Accountability Project, the leading whistleblowers protection organization in the United States. David has extensive public sector and private sector experience. He has served in senior position in the U.S. Department of Justice as white-collar prosecutor and U.S. Senate and U.S. Department of State's Office of Inspector General. As a former partner in international law firms, represented the private clients and corporations in official investigations. Since joining the Government Accountability Project in 2019, David has represented dozens of whistleblowers in investigations conducted by the US Congress and the US government. So David's presentation is entitled Case Studies on Whistleblowing Leading to Formal Government Investigation. And I'm very, very thankful, David, to have you here. So David, cool, the floor is yours, and you can try to share your slides.
Thank you, Costantino. And I am in Washington, D.C., where the weather is very nice today. So with that in mind, the Government Accountability Project has been in the business of whistleblowing for over 40 years. And we have represented thousands of whistleblowers over that period, both in the public sector and the private sector. And to pick up on our last speaker, I wanted to build on that, in that whistleblowing and the tools used in whistleblowing are many. And we've just heard about, in particular, how internal investigations at the organization or company level lead to additional things, in particular, formal government investigations. And the way we, as whistleblowing lawyers, see things, the world is divided into two parts for whistleblowers. One part is the whistleblower who wants to disclose or report something bad in their organization. They may have no vested interest, they may have no issues whatsoever. They just see something bad and they want to report it. Another part of whistleblowing is people who have reported things and who have been retaliated against, who have been victims of adverse action, whether it's firing, demotion, smearing of reputations. There's a wide variety of things. And under US law, that is illegal. It's illegal both in the public sector, and depending on what part of the private sector we're talking about, it's illegal there. And in a few minutes, I'll get to the case study that will address that. So from our point of view, from a whistleblower lawyer's point of view, we're engaged on multiple levels at the same time. And so let me start sharing the screens to give you sort of a sense of this. Bear with me. Okay, so I'm going to start with the general methodology that it's employed, at least by GAAP in general. And you'll see there are multiple points in which whistleblowers can engage the government in a variety of ways. So, and all of these ways are that it's not a one or exclusive way. There are many ways, and they tend to be reinforcing of each other. So for instance, if we look at this chart here, it may begin with media outreach, which means that the media writes stories about the bad problem that the whistleblower is talking about. That in turn may lead to investigations, both internal or external, to determine what exactly are the reports. That in turn may lead to public hearings by, say, the US Congress and or government agencies that are responsible for the particular area. So for instance, if it's in a nuclear area, which GAAP has been very involved in, it might be the Nuclear Regulatory Commission. If it's in the justice area, it may be the Justice Department and bodies within the Justice Department. That in turn leads to, or again, these are all in parallel, it's not one after the other, legal protection that the government or the laws provide. And at the same time that all that is going on, we are engaged in public education on a continuous basis through media outlets, through reports we write, and we work with many allies and many coalitions. So from our point of view, that there's a critical mass of activities, and there are more activities, but I want to just give you a sense that they all can work together. So for instance, just to, in a little example, lawyers may report something to say the Congress, but may do that in a very public way. We might send a letter to the Congress. We would also send it to the head of, say, a government agency. And we would also issue a press release at the same time, including our letter. So it's in the public domain, and others see it and are attracted to it. That in turn may lead, for instance, the Congress to contact the public agency to say, we're very interested in this and we want you to investigate. Now, in the United States, government agencies and the Congress are separate branches of government. They don't control each other, but they pay attention to things like that. And so a letter from a senator to, say, an investigating agency might motivate that agency to work a little harder looking into the issue. That agency might in turn issue a report on what was reported, which in turn the senator would want to use, say, to hold a hearing on the subject. So when I say these are reinforcing issues, that you can see how this happens. And in the meantime, the media is involved, the public is informed. So the methodology is laid out in general here. So with that in mind, I'm going to tell you a little bit more detail about Government Accountability Project, or GAP. Our roots go back to go back to the Pentagon Papers in the 1970s, and we trace our roots to folks like Daniel Ellsberg, obviously in particular. But in the wake of that, there were multiple formal government actions that obviously took place in terms of, among other things, legal investigations, trials, media exposure. They all came into play with respect to that issue. GAP has, over our 40 years, I just want to give you a sense of some other issues where we've been very involved. And the nuclear or anti-nuclear movement has been central to our mission for a long time. So, for instance, just of recent note, the meltdown and disaster at 3 Mile Island in Pennsylvania back in the late 70s spurred many more actions, much more focus on the issue. And to the extent folks are interested in this, in 2022, Netflix produced a documentary on our work. So we obviously recommend it. But I just want to give you a sense of what we're doing more lately. So for instance, in the past few years under the Biden administration, the president's science advisor was engaged in improper conduct involving a toxic workplace. He was abusive to staff, and when I mean abusive, I mean he was yelling at staff and such. That's sort of an unhealthy, toxic workplace. That in turn led whistleblowers to come forward and report this to the White House, which in turn conducted an internal investigation, which found that in fact the advisor was doing those things, which in turn ultimately led to media reports on this, which ultimately led to the resignation of the science advisor. And in the meantime, there were other oversight agencies within the U.S. government that were interested in looking at this. I tell you all this because we represented the whistleblowers in this matter, and that's just an example where all of the things I've been talking about, all the methodologies come into play. So a few more recent examples from this year that I'll quickly talk about. One matter before this that the Senate Judiciary Committee held a hearing on solitary confinement in prisons in particular, and the adverse effects that has on prisoners. Now, that hearing, if nothing else, showed a spotlight on the issue. And it's a form of government investigation. The hearing itself didn't lead to the passage of laws. But one of the Congress's many, many helpful things that it does is by holding hearings, it focuses on issues and creates what we call the critical mass of interest in the issue that continues to be picked up over time. Even more recent example is the issue of climate science, and we represented and represent climate scientists who were retaliated against, in particular during the Trump years, and in substantial part were whistleblowers who we have represented. And those whistleblowers, the article that you see on the lower left here, is talking about the future. In other words, if, say, former President Trump were to win the election, it's likely that climate science would be under attack again. And our whistleblowing climate clients would want to raise those issues yet again. And so we look at the past, present, and future on these issues at all times. So now I'm going to go into a little more depth and talk about two case studies, one involving the Enron Corporation and the other involving Union Bank of Switzerland. Now, when we talk about Enron, everyone knows about the Enron scandals. Enron was a major US corporation in the energy markets. It was at its time viewed as a stellar corporation. It's you pick your big American company, and it was a leader in that area, and particularly in areas of trading of energy trading, which is a multi-billion, if not multi-trillion-dollar business. And energy trading, I mean the cost of oil, the cost of electricity, things like that. Well, newspaper reporters began to ask whether Enron was too good to be true. And so in the latter half of 2000 and in early 2001, a series of articles began to run in major US financial outlets like the Wall Street Journal, Fortune magazine, with stories about, is Enron overpriced? Is there more air there than is the balloon, is this just a balloon? Is it a bubble, or is there something more there? At that point in time, there's a certain level of skepticism that why would anybody question if there's any worth there? So needless to say, there was it was debatable in the beginning, but as time went on and employees at Enron saw these issues, they began to report them in different ways. And so so for instance, one of those people is Sharon Watkins, who was named Time Magazine Person of the Year. She's on the far right here. And in August of 2001, the president of Enron, Jeffrey Skillings, resigned. And the next day, Ms. Watkins sent a long memo to the CEO of Enron, Kenneth Lay, laying out in chapter and verse what's going on here. I believe it's an 8-page memo that says there are really problems here. We're looking at scandal, and things have to be done. Now at this point in the summer of 2001, things were percolating, so to speak. And that in turn led Enron to hire law firms and accounting firms to look at the books and accounting records. And by the fall of 2001, those internal investigations reported that Enron had misrepresented its profits, as you can see in this New York Times article, by $600 million. Now, that in turn triggered multiple investigation. So for instance, right about that time, the U.S. Securities and Exchange Commission opened an investigation of Enron into these issues. And a few months later, that civil investigation became a criminal investigation. And as you all know, the leaders of Enron were prosecuted and convicted of that. So that's a case where whistleblowers have come forward, reported internally, have not necessarily triggered internal investigations or government investigations, but they're part of the totality of the methodology I've been talking about earlier today. Now to come back to Sharon Watkins in particular, so on the one hand, she wound up being a witness in the criminal trials we're talking about. But she also wound up going before the U.S. Congress and testifying about these issues. And so, and among the issues she identified was that once she reported these issues, Enron, the management of Enron were about to retaliate against her, or were contemplating retaliation in various ways, because she was a troublemaker, she was a snitch, she was ratting out the company. Now, those
We can't hear anymore.
Hello, David. I cannot hear you anymore.
You have to unmute yourself.
I'm unmuted. I'm not muted now. So, David, do you hear me? Your sound is not there. Not because you have already going past 15 minutes, but just because the sound is not there. But you're not muted. I don't know what's happening.
How about now?
That's good. That's good. So can you just go back like 1 minute, something like 30
Sure.
seconds? Yeah, thank you.
Right. So I got to we were talking about how executives of Enron were convicted and went to prison, and in addition, Sharon Watkins, the whistleblower I was talking about, testified before the United States Congress, in particular, about the problems at Enron, and more significantly for us, how she was about to be the victim of retaliation. She was about to be fired. Her reputation was going to be damaged. And that created the critical mass that I've been talking about that led to the passage in July of 2001 of the Sarbanes-Oxley Act. And when this became law, July 2002, it has specific provisions who protect employees of publicly traded companies who provide evidence of fraud. So in other words, if I happen to be an employee of, say, Microsoft, and I discover fraud and I report it to my manager, and then I'm suddenly, I never get a promotion again, or I'm fired, that may in fact be illegal, and employees have rights, legal rights they can pursue. Sarbanes-Oxley Act was also important, though, because it created what we call the whistleblower programs at various federal agencies, in particular at the Securities and Exchange Commission. Up till that point, the SEC hadn't a formal program, but under the program, among other things, it now awards rewards or bounties to whistleblowers who report fraud, and they receive a percentage that the SEC determines based on a variety of factors as to how significant, large the award can be. So in this case, we're looking at a $24 million award back this past August. But to give you a sense of how popular this has become, we put together this little chart that shows the increase in numbers of whistleblower tips over the last 10 years. So As you can see, back in 2012, there was something on the order of 3,000 whistleblower tips. And by tips, I mean people sending in emails, calling up as a telephone hotline. There's a variety of ways of making tips to the SEC, which the SEC staff obviously then review. But you can see the numbers have spiked dramatically. So, you know, in the last fiscal year, we went from 3,000 10 years ago to 18,000. Now, the issues, among other things, are the SEC hasn't quadrupled the number of staff working on whistleblower cases. So that presents a challenge in and of itself. But we show you this to suggest that programs protecting whistleblowers do, in fact, work. And I'm going to give you just another example involving Union Bank of Switzerland, so in this particular case, an employee named Bradley Birkenfeld learned in 2005 that the bank was providing illegal advice to clients, mostly or principally involving tax evasion, that they were setting up secret accounts and anonymous names to avoid paying taxes in their jurisdiction. Well, that triggered, among other things, government investigations, and is relevant here. UBS as part of a resolution of the criminal investigation, agreed to pay the United States government $780 million fine. But that was only a piece of it, because if we look what Mr. Birkenfeld contributed to, in addition to that fine, 250 very rich Americans were identified who had been evading taxes. Over 4,000 additional accounts were identified. There were 120 criminal indictments in the United States, many in foreign jurisdictions, the closure of Swiss banks. And the U.S. Internal Revenue Service has collected over $5 billion based on all this. But there's sort of a not so great side to this too, which is Mr. Birkenfeld had criminal problems of his own. And, people might argue, or do argue, that in fact, his motivations were not entirely pure. He came forward to as we say, take the heat off himself to some extent. But he wound up pleading guilty to tax crimes, and in fact was spent some time in prison, 2 years in prison. On the other hand, given that he recovered billions of dollars for the United States, he also received $104 million reward from the IRS as part of their whistleblower program. So you could see from the article, it says, sometimes crime does pay. And it talks about Mr. Birkenfeld getting out of prison and being rewarded like this. What has happened to date is whistleblower programs in the United States on the government side have expanded well beyond just the Securities and Exchange Commission or the Internal Revenue Service. So in particular, in the last few months, the Justice Department has announced its own program to do exactly what the SEC and IRS do, to encourage whistleblowers to come forward to report matters, and it can be done, and is often done anonymously. And we as lawyers work very diligently with our clients to protect their anonymity and to protect their legal rights. But know that, at least in the United States, this is a growing, emerging space. It's remarkable what has happened over the last 40 years. Our work is by no means over, but over that time we've shown progress, and I expect we'll show significant future progress. So with that, I am finished. So thank you for your time.
Thank you very much. Thank you very much, David. Thank you. So, okay. David, your presentation was very, very, very relevant, and especially in relation to, when you mentioned the Enron case, because we have a structural deficiency in economic crime and criminal accountability when we don't have evidence to demonstrate that CEOs of big companies are always involved in these big scandals, but Enron demonstrated the opposite just because the whistleblower were there and were pointing the finger to them and say, you know everything. You cannot say as usual, I didn't know, it was negligence, but there was no intent. So, but that was an exceptional case because Enron was, collapsing. That was a big thing. But for ordinary corruption cases, I don't see this happening. So yeah, we really need the whistleblowers. And I really liked when you said about the dualism that we have in approaches to whistleblowers. The ones that speak the truth about a competitor or a different organization. So they're great. We want to protect them. We want to help them. And then there are the one that point the finger to your own organization, and they are a loyal, disgruntled employees. We don't have to defend them. What does this demonstrate? That there is a high level still of organizational hypocrisy. There is reluctance to accept accountability, and there is a need for cultural change that we have to foster and fight for it. So thank you very much. It was very, very interesting presentation. Now I will introduce Elisa Renzi. Elisa is a captain of Italia Guardia di Finanza, a tax police mainly engaged in combating financial economic crimes. She has served first in the Naples group, where she worked in various law enforcement operations, including anti-drugs trafficking and anti-smuggling operations. Then in 2022, she was assigned to the company of Spoleto as the commander of the unit, engaging in different missions, prevent and repress crimes against the public administration, like the undue perception on national and EU resources. That's a nice way to say corruption, but I like it. So yeah, thank you very much. Elisa's presentation is entitled Uncovering Corruption in Waste Management. So Elisa, the floor is yours. 15 minutes, please, Elisa. Let's go ahead.
So, good evening, professors, colleagues. And I want, first of all, thank you, Professor Grasso, for letting me to join this meeting. So I'm bringing here a recent case in which our whistleblower report sparked the action of Guardia di Finanza, leading us to successful criminal proceeding. In 2022, an employee of a state-owned company gave important information to the Guardia di Finanza officials about a bribery fraud involving high-profile figures in the garbage collection services in Lazio region. The employee didn't use the internal system for reporting breach of regulation, so he chose to bypass the ordinary path to disclose information about the fraud directly to us. In Italy, legislation is provided that in a case a whistleblower or a leaker can't approach the internal reporting system, they can refer to national authorities or to regulatory bodies directly. So,
Elisa, please, can you speak next to the microphone?
Can you hear me?
Yeah, speak just a bit louder and it will be fine. Thank you very much.
Okay. So we started first recognizing the public procurement gained by the company we are first focusing on, that we can call from now on Alpha Company to simplify things. After a public tender procedure, it was about the garbage management in 10 municipalities, and the duration of the contract was 10 years. The total amount of the long-term service was 75 million euro. The Alpha Company is a state-owned enterprise. It means that everything is funded by public money. As in most countries, in Italian law, the legal representative of a state-owned enterprise held the public official status. The Alpha Company, in accomplishing the first main contract, needed agreements with two other subsidiary firms to perform other two further services linked with the public garbage management, which were then the organic trash disposal and the garbage can supply. As revealed by our whistleblower, we discovered that the Alpha CEO made financial consulting activities in favor of the two chosen subcontractors without any kind of professional skills in the topic. So we could see that the two companies paid more than 700,000 euro of invoices to the Alpha chief executive under the disguise of a legal professional service without any kind of economic needs. Actually, it was an economic, it was the that price with the bribery itself. It was paid for achieving the public procurement, killing off all the competition around. Moreover, through database checks, we discovered the really strange high living standards for the Alpha administrator, such as luxury cars or yachts or luxury watches. And that situation seemed contrasting to his normal employment. Finally, all the collected elements led us to report clearly the crime offense to the public prosecutor, letting the inquiry start. The whistleblower cooperated all of the investigation time by giving new information to me and my colleagues, and for all the time in the most safe form for her. According to our legal system, law enforcement authorities have to protect whistleblowers' identity, both in first part and when the investigation ends. So we never revealed the name of the employee to anyone but the prosecutor. So the crime report develops in outlining the charges against the Alpha chief executive for 318 and 319 articles of Italian Criminal Code. These offenses are recognized as public official corruption in two different ways. The 318 article punishes bribery for the performance of the function, which occurs when the public official, in connection with the performance of his function or powers, unduly receives for a third party money or other things of value. Whilst the 319 article punished the public official that shirked duties in exchange of benefits from third parties. The public prosecutor, delegated after the crime report, after some decisions that he took, delegated the Guardia di Finanza to intercept the Alpha CEO, as well as the two subcontractors. In Italian law, there are specific requirements that allow the police to wiretap communication, such as the authorization of pretrial judge. Moreover, they are allowed for some more serious type of offenses punished with more than 5 years of imprisonment. So all the operation of wiretapping, search on databases, tailing suspects last for about 8 months. At the end of them, we was able to ask to the public prosecutor a local search decree to find all the evidences on what we heard in wiretapping and to discover more clues against the 3 suspects. So we conducted all-in-ones 3 local searches in the administrators' houses, in their chambers, finding all the proofs of bribery sufficient to support the charges against them. The whole documentation about the work procedure of the subcontracts, of course, have been seized. Above all, no studies, no records were founded by us proving the existence of the consulting activities. And this fact affirmed that the hypothesis of misinvoicing illicit was true. Once again, the whistleblower contribution were meaningful in getting clues. As quickly as possible, pointing our focus on the right places rather than losing time in empty offices. And okay, so we can see now the type of subcontracts done. And as a result of the investigation of the collecting of all this evidence, we figure out that the corrupted system put in place by the Alpha CEO was articulated in this way. So the first subcontractor was chosen in exchange of a bill of 650,000 euro for fake consulting service. As we can see, the amount of the subcontract of organic waste disposal was 20 million euro. Okay. And for the second one, the second subcontractor was chosen in exchange of a bill of 50,000 euro for fixed consultation. Here, the amount of the subcontract for the garbage bin supply was 3 million euro. Even here, the garbage bin supply was for 10 years. And of course, the kickback here worth it proportionally less than the first one. And on completion of the operation, basing on all strong evidence of illegal dealings, the judge approved the prosecutor's decree of measures against the 3 managers under investigation. Me and my colleagues executed the preventive prison for corruptors and the corrupted with an amount of 700,000 euro as the result of bribery benefits has been seized against the Alpha CEO, both on his bank account and among his real estate. And so all the investigation finished. And this epilogue suits exactly the goal aimed by a whistleblower or a lacker's disclosure. Often, national police force have to face big challenges with limited resources or not enough time to investigate. So these people's brave behavior really help to pursue the justice, mostly when it is difficult to uncover the wrongdoing schemes and to construct the truth.
Thank you very much, Elisa. Thank you very much. And it was a very, very interesting presentation. And I liked very much the final words. It's so important that you recognize as a member of the authorities that the lack of resources, that is structural everywhere, even for the Guardia di Finanza, this is one of the most efficient corps in the world, make you a passive recipient of information. You cannot go there and look at all the cases and get them. And, you know, and it's amazing also, you know, the case that you select, because it's so interesting to note that after all the focus that in the EU has been given to fight corrupt practices, the public procurement processes, that, I mean, we fight that as the most important thing in Europe, still, and even in a sector like waste management, where we know very well there is so much of mafia-type organization infiltration, still we need whistleblowers to come out. I mean, and because, you know, that's the reality. So that's why we need them. And so let's imagine in other sectors, Elisa, where there is not so much, you know, they are not under the lens of the regulators. We will never discover things. So yeah, thank you very much. It was a great presentation. Let's go for next panelist, that is Ian Foxley. Ian is a British Army veteran with 24 years of service. He's also a lecturer at the Army Command and Staff College, and spent 2 years in counter-terrorism, followed by a secondment to the Australian Army. After leaving the military, Ian worked in telecommunications, where he blew the whistle on corrupt payments related to the UK-Saudi defense contract. His actions led to a 3.6 billion fine for Airbus and significant corporate changes. He founded then Whistleblowers UK and Parresia Incorporated, organization that support whistleblowers and advocate for legislative reforms. Ian holds a PhD in politics, a Master of Art in Applied Human Rights from the University of York. Ian, it's a privilege to have you with us today. Please join us. Ian, the floor is yours. Thank you very much.
Thank you very much. Good evening, everyone, online and in the room. I'm going to talk about the revelation of wrongdoing from the perspective of the whistleblower. I'm not actually going to tell you my story. If you want to find it, it's out there. Just Google me, you'll find me. In fact, you get about 5 pages and a number of different presentations, and actually a television program as well, if you want to read it. I'm going to deal with this conceptually, saying that at the beginning of any whistleblowing disclosure, it comes from an observation of the individual that something is wrong. Something is wrong in your environment, your work environment, or maybe your home environment, or maybe your organizational environment. But there's something that's not quite right. And it doesn't fit with your experience. It doesn't fit with your training. It doesn't fit with your knowledge bank. It doesn't fit with your upbringing. There are a number of different influences that bring you to a point where you suspect something. And it's like crossing a bridge. You start on one side with a suspicion, and as you head across that bridge, as you gain knowledge, you're led to a point where suspicion turns into knowledge. And at that point in time, you have a decision to make. And this is a key point in the whistleblowing process. It's not just about finding out, it's about what are you then going to do about it? Because if you do nothing and you know, then you are complicit. If you do something, then you have to decide what you're going to do and how you're going to do it. Because in some cases, it is not just going to impact on your personal and your professional life, it's actually going to threaten your life. And that actually happened to me. You're faced with what I call the man in the mirror moment, where your second revelation, the first revelation is that something's wrong, and that then leads to it's something I have to do about it. Your next revelation is a personal revelation. It's a revelation about yourself. And it's a revelation about whether you're actually going to act on that knowledge of wrongdoing. And if you look at yourself in the mirror, there are only 2 people there. There's only you and your God or your soul looking back at you. And you have to reconcile yourself to that, because the decision you make in that moment will live with you for the rest of your life. Because you are either going to take a step forward into danger, or you're going to take a step backwards or sideways, and you have to live with that decision. It's based on your value set. And I touched on it earlier. It's about your parentage, where you're brought up, the value set that you are given, the ethnic group and the culture that you're raised in, your professional connections and your professional training, your experience throughout your life, not just in your professional world, and the loyalties that impose on you. And there are a lot of competing loyalties which seek to drag you in either direction. And you have that moment. Mine was on the 5th of December, 2010. I call it my Gethsemane night. I'm Catholic, by the way. And you have a devil on one shoulder and an angel on the other, arguing through you as to what you could do and what you should do. Albert Hirschman wrote a book called Exit, Voice, and Loyalty. And he gives you the 3 choices, really, of what you can do. He also adds in a 4th one of neglect, but I'll come to that in a moment, in the more negative side of what you may not do. Voice is speaking up. It's the one choice. Exit, leave the situation, run away, or safeguard yourself, but do nothing. That's more on the negative side, heading to the right on this diagram. Or loyalty, he puts it, loyalty to your colleagues, loyalty to the organization, and the ideals of what it stands for, albeit that you may not agree with them, you're overpowered by loyalty to the organization. If you remain within the organization, though, and this is where the neglect side comes in, you experience a kind of cognitive dissonance, which is a psychological battle between your knowledge of what is right and your inability to do the right thing. And that creates a psychological pain within you, which leads you actually to lower efficiency in your workplace, a degradation in your relationships, and actually a chronic illness. I want to point out something about the whistleblower paradox. Irving Goffman talks about the management of stigma and a troubled identity, where society is formed from the norms of behavior. The majority of people gather together and bond together because we act, we eat, we are safer, we can feed one another if we stay together and obey the norms of behavior of society. And amongst that also is this idea of the abnormal, those who step outside society and who are then stigmatized. The word stigma comes from the Greek word for a mark. They are marked as being outside of society. In ancient Greece, they actually branded people, and that actually carried across into medieval Europe as well. But what happens when you become the whistleblower? When you step outside the norm of the business, the norms of your colleagues in a workplace, to actually blow the whistle? You take a pace into abnormality because that's not what the norm is. But I suggest that there is another group, and I point now to the supranormal, those who are the whistleblowers, I would say it, wouldn't I, who are the conscience of society. If you take a normal distribution across a population, at the bottom end, you have your abnormal. We have the 2%. There's always a 2% who are a bad lot, the bad apples in the barrel. But you also have the 2% at the top end, who are the supranormal. And what I suggest is that what we have to do is skew this curve so that we reduce the abnormal and we increase the supranormal. We induce more people to actually stand up and speak up. I did my PhD at York 2 years ago, graduated 2 years ago, looking at why people do not speak up. The grand title was Contextualizing Whistleblowing in Institutional, state institutions. But what I was really doing was getting down to the root cause of why people don't speak up. The primary cause is fear. Fear of the loss of 4 key things which keep you sane in life: your home, your health, your work, and your wealth. And when you blow the whistle, the first thing you lose is that you lose your job. You lose your work. The second thing you lose is you lose your savings. You lose your revenue. Your outcomes, your outgoings retain, but your income diminishes. You lose your health because you're under tremendous stress, and that carries across into physical degradation as well. And if you're not lucky and you don't have a very secure, close circuit of friends and a very stable family relationship, you lose your home as well. And then you have nothing to hold you on that rock wall of life. You're in freefall. The second primary cause of silence is futility, a sense of ineffectiveness. The idea that I'm too small, you're too big, and you'll just tread on me. I will put my foot in the minefield, but all that will happen is I get my legs blown off. So why do it in the first place? The third idea is this idea, sometimes imposed on you, that you are complicit. You've been given that small hook and you've been drawn in, and you're now part of the corporate organization. And if they go, then you go as well. And therefore you keep quiet, or you are induced to keep quiet. The fourth zone I'll come to in greater detail in a moment. I call it the gray zone. In fact, Primo Levi called it the gray zone. This idea that there is an area between black and white, which merges and is a very difficult area where, in terms of whistleblowing, the individual is not brave enough or feels not brave enough or secure enough to blow the whistle. but actually wants to retain their self-esteem. They want to believe that they are good, and therefore they find another way to leak the information. It's the classic civil service leak, is this third area. The last area is below the line, because the last cause of individual silence is actually the consequentialist or utilitarian view. The idea that we're doing it for the greater good of the greater number. I'm doing it for the business because we get more sales, we get more profit, we all have secure jobs. The politician says, I do it because we need the strategic ally. We have to dirty our hands, Sartre's les mains sales. The idea that for the noble cause, I act and do something which you may not like. Let me return to this idea of guerrilla government, this idea of the civil service leaking the information. And this is in terms of the ecosystem of truth that we're working on with Professor Grasso here, is the second pillar. The first pillar is whistleblowers, the individual exposure of wrongdoing. The second is the leak. Where does it come from? How do we deal with it? And in this idea of revelation of wrongdoing, there are, I believe, 5 revelations. I might be wrong. I'm putting this out there. If you want to tell me I'm wrong or come back to me, then I'm delighted. Let's take the discussion further. The first revelation on the left-hand side is this first recognition of the event of something wrong and it being wrong, doing, not just a suspicion or knowledge. You know it's wrong. The second one is the personal revelation of what am I? What do I stand for and what am I going to do about this? The third revelation is the revelation to the authority, to someone like the Guardia Finanza, to tell them that something has to be done. And it's a revelation to someone who has the ability and the authority to do something about it. The fourth revelation sometimes is the external revelation. It's the revelation to the public, because remember, when you talk to the authority may be your own business or it may be a law enforcement agency, but that is confidential, it's internal. Sometimes when you do not get the right answer or the right response, you do go external, or as in my case, you are doorstepped because somebody else has told the media and you are doorstepped and you are then demanded to comment. Saying no comment merely leaves you open to attack. The last revelation is something that I think we want to explore, and that is the revelation back to leadership. Leadership of the organization or leadership in governmental terms, that there is something wrong, and in the greater sense, socially, we have to do something about it. And that's an idea that I want to explore in discussion or in the project that we're talking about. Let me turn now to the third pillar, which is investigative journalism. And by that, I mean online as well as in print. And here's a number of famous ones in our country. What does a whistleblower do for the investigative journalist? Well, you are the intimate source of knowledge about what's been going on. In intelligence terms, you are the source. And intelligence terms, in my world, in military intelligence, the key thing you do is protect the source. Protect their confidentiality. Ideally, you keep them in the situation because they continue to feed you information until such a point in time as you're ready to go, you act. But the key thing you do is protect the whistleblower. In our world in the UK, we haven't got that right. We need to make it right. They bring you inside information. The one person who knows exactly who's doing what and where and how and when is the whistleblower, because they brought it to you. And they will understand the nuances, they'll understand the context, they'll understand where the information can be got and what you can do with it. And they can provide you with documented evidence. For the investigative journalists, of course, they can bring you a scoop. But there's a quid pro quo there, and I'll come to that in a moment. And the last thing that they give you is credibility and validity to the revelation. You have a trusted source if you're the journalist. You know where the information is coming from, and hopefully you've got the documentary evidence. So let's flip the coin and say, what does the investigative journalist do for the whistleblower? Well, it's here. They give you reach. They give your voice amplification. They give you validity because they're going to investigate you and the credibility of your information and you as a person. No matter what the organization does to try and destroy you professionally and personally, and they will, the journalist will have been there before and proven your, I would say, the sacredness of your information. They provide you with a network of open source intelligence. And again, I want to come to that in a moment. And they provide you with this resource of investigative capability, a network of contacts, the ability and the time, they're salaried, you're not, to be able to go and track down bits of information which knit it all together. The challenges, of course, predominantly are for the security of the individual and the security and safety of the knowledge. And I align totally to the American idea that SEC and David was talking about earlier, of the confidentiality of the individual and the information until such time as you're ready to take judicial process. It's absolutely key to it all. And opportunities. Professor Grasso talks about this idea of the project that we're trying to have taken up within the EU to create a capability which ties together the sources of the information to the law enforcement agencies and creates a network of open source intelligence, which then propagates the ability and efficiency of investigations. The opportunity is it's I think 25 different partners. Pahisa is one, and Manchester University are another, MMU, sorry. To investigate this ecosystem of truth, it's a great term, to create a network of open source intelligence and look at, technically how artificial intelligence can actually apply it in the future. And my time's out. There you go.
Thank you very much. Yeah, thank you so much. It was an amazing presentation. I mean, there's so many comments, but we don't have time. So let me just be quick what I would like to say. But first of all, thank you. I mean, I don't know if my students understand how lucky they are today. That's something that, you should be very aware of. This is a fantastic event. You are exposed to things that are real life application of law in an area that is at the edge of a revolution. It's a revolutionary area. So, yeah, and what about what you said? I think you demonstrated how limited we are as lawyers. And we would like to rule about this without looking at sociology, anthropology, psychology, how we can do that. We really need an interdisciplinary approach to whistleblowing. And the first part of your presentation was about that. But that also you said, I really like when you spoke about the two types of anomalies. And yeah, maybe what I really think is that we can start doing one thing. We need a cultural transition from what you define about normality to supernormality. So we have to be clear, whistleblowers are heroes. Speaking the truth has never been for everybody, never in history. Okay, it's always been problematic. And being a hero is always been, in a way, not normal. But these are the good people that we need. So we have just to consider them as they are. They are heroes. They need our protection and they need our support, unconditioned. So that's what we have to change. And then you said, oh, another thing that we have to fight. I agree with you. On a philosophical level, we have to fight the pervasiveness of an utilitarian approach in this area. It doesn't work with whistleblowing. Here it doesn't work. We have to be Kantian here. We have to be Kantian. We cannot be utilitarian. And then I like when you said, and this is a critical bridge with the next author, panelist that will be Mary, when you said, their intelligence, we need to keep them in their position, because we want to not to get as much information, but we need a structure to do that. And I also remember a case that Mary was following, that is the Takata scandal. You remember when they knew about things, they didn't speak immediately, they waited, they collect evidence, they stay there, but they were guided. They were guided by senior people, lawyers. Whistleblowers need guidance. And it's very difficult to give them every time. Sometimes they are whistleblowers, they don't even know that they are whistleblowers. So yeah, so with this, so thank you so much. With these words, I will just go to Mary now. So Mary Inman. Mary is partner in the San Francisco office of Whistleblower Partners LLP. She's a veteran whistleblower lawyer, having worked representing whistleblowers for the past 26 years. She has helped her clients, including Theranos and Facebook whistleblowers, forge a partnership with government agencies that leverage whistleblower information to expose corporate frauds. She's an internationally recognized expert on whistleblowing, as well as about the extraditional reach of US whistleblower reward programs. And we are delighted to have Mary as part of our team at the Corporate Crime Observatory as our head of area for the study of whistleblowing in the private sector. So Mary's presentation is entitled "From FinCEN Files Leaks to the Whistleblower Reward Program, How Natalie Howard's Leaks Led to a Change in Governance." So Mary, the floor is yours. Please, Mary, 15 minutes because we are going out of time. Thank you so much.
Thank you so much, Costa. Can everybody hear me okay? Sounds like okay. All right. So I'd like to share my screen with everybody. And that's what I'll do right now. Okay. So it's with great pleasure that I talk to you all about a case study involving a whistleblower who I believe firmly does not get enough credit. So her name is Natalie Edwards, and she is a government whistleblower. And as my title slide here suggests, she occupies and holds many different roles. And we'll walk through those roles today. She was an internal whistleblower before she ever went external. She could be described, and I think that's something for us to discuss, as a leaker. She went to the media. As a result of going to the media and sharing information, she ultimately was criminally convicted and became a prisoner. And in her long role, she was really the inspiration and the source behind the FinCEN files, which is up there with the Panama Papers and other great investigative journalism by the ICIJ. And she's really the impetus, I can't say inspiration, but she's the impetus for the FinCEN Whistleblower Reward Program in the United States. So let's walk through this journey. It's rather remarkable, and really look at the woman behind this program. So I'm not sure why my slides aren't advancing. I apologize here. There we go. So let's start with the first part of her journey. There's Natalie there. She served within the Financial Crimes Enforcement Network in the United States government in the Treasury Department. She served as a senior advisor. She brought concerns about the fact that she believed that FinCEN itself was not doing its job. We're going to talk a little bit about what FinCEN's job is. They weren't doing their job, and were basically not acting on suspicious activity reports, which we'll discuss in a second, are things that the banks and financial institutions must share with FinCEN when they believe that there may be suspicious activities going on in banking transactions. So she starts and expresses her concerns internally, and the scope of what she observed was she looked at over 200,000 suspicious activity reports over close to a 10-year period, showing transactional financial transactions valued at close to $2 trillion, showing that the banks that filed the SARs may have been slow pedaling the filing of these SARs. So the part of this story is that she starts internal, just like many whistleblowers. Her first thought is not to go immediately external to the media or to the government. She starts internal with her employer, who happens to be the government. So I think that's another really important part of his story with Natalie, is that she's a government whistleblower. She's not a private whistleblower. And we've heard earlier from David, who works for the Government Accountability Project, who sits as an NGO helping government whistleblowers who try to expose wrongdoing by the government. And here, Natalie is believing that her organization, FinCEN, is not doing its job, is sort of asleep at the switch. So a little bit of the background. Again, FinCEN is a bureau inside the Treasury Department in the United States. That's where Natalie worked. Their job is to collect and analyze financial information to combat money laundering, terrorist financing, evasion of economic sanctions, and other financial crimes. So obviously they have a very important remit as a bulwark against the manipulation and abuse of the U.S. Global banking system. The other background you need to know, because what Natalie leaked were SARS, is that financial institutions are required under U.S. law to file suspicious activity reports with FinCEN, that division within Treasury, when they suspect that their clients are engaging in financial crime. It's important to note that SARS themselves are not necessarily evidence of a crime, but they provide important information to investigate crimes. So Natalie starts internally and complains about using what she says to be the internal reporting mechanisms that the Treasury Department has. When she is ignored, and I should note as an asterisk, she ultimately becomes prosecuted, and it's contested whether or not she actually did report internally as a whistleblower. The prosecutor said that they didn't see sufficient evidence of this. She maintains that she did. So I just wanted to point that that's a contested fact, whether or not she was actually an internal whistleblower. But assuming she did report internally, she was rebuffed, at least by her own account. She was then retaliated against for bringing that information inside FinCEN, and this is what serves as the impetus, one of the motives for her to go external and bring her information to the reporter you see there on the screen, who is a BuzzFeed News reporter, Jason Leopold. So she decides to start cooperating with him. And the other impetus she has is obviously, and I think first and foremost in her mind, is that she believes that, like most whistleblowers, that there is wrongdoing that has occurred, not just by FinCEN not doing its job effectively and really acting on the suspicious activity reports to prosecute and take enforcement action against some of these banks, but also she's exposing the fact that she felt that these underlying banks have engaged in potentially criminal activity. So that's what happens first. The question is she a leaker? You know, when we talk about the Panama Papers leakers, that person is a leaker, has been determined to be a leaker, having also provided like thousands and thousands of files to Süddeutsche Zeitung and ICIJ. I think it's an open question. You could also just call her a media source. She went to Jason Leopold to provide this information, and ultimately was an anonymous source until she later gets divulged and prosecuted. So we'll get to that part of the story later. But what she does after having been rebuffed based on her internal reporting and the fact that she felt like they weren't addressing her concerns at FinCEN, she goes and starts cooperating. What this leads to is BuzzFeed, as we've seen in the Panama Papers, Paradise Papers, BuzzFeed does what we see ICIJ to have done, is they enlist the help of ICIJ, the International Consortium of Investigative Journalists, who then deploys over 108 media organizations, and they take the substantial amount of information that Natalie provides from inside FinCEN, again, over 2,000 suspicious activity reports, and other inside documents and memos from the Treasury Department, and they produced something called the FinCEN files. The FinCEN files really end up exposing, after all of these media organizations sort through all of the data, expose how global banking systems enabled money laundering and other crimes and profited from criminals. So she's really the source behind the FinCEN files investigation. A little bit more about the FinCEN files. Again, it's ICIJ that took the lead and worked with BuzzFeed and Jason Leopold on this story. And they really, the story has a very large global impact. Here's just a few quotes about the significance of it. And what she was able to do. The Miami Herald says that the FinCEN files were the most detailed U.S. Treasury records ever leaked, over 200,000 SARS. BuzzFeed News says that the files offer an unprecedented view of global financial corruption, the banks enabling it, and the government agencies that watch as it flourishes. Some of the banks that BuzzFeed named as involved in the money laundering that's sort of exposed by these records were JP Morgan, Chase, HSBC, Standard Chartered, Deutsche Bank, Bank of New York Mellon. And finally, the BBC says that the investigation shows how the world's biggest banks have allowed criminals to move dirty money around the world. So clearly she has exposed, and with her information, these journalists are able to sort through and tell quite the story about the global banking system and some enormous lapses in terms of the regulators and the movement of money and the slow peddling that these banks were alleged to have been slow in filing these reports, these suspicious activity reports, which are allowing them to onboard some of these clients engaged in suspicious activity. Who are some of the prominent individuals who are highlighted in the FinCEN files leaks? Donald Trump's former campaign manager, Paul Manafort, an Iranian Turkish gold trader, Reza Zarrab, and now infamous Malaysian businessman, J-Lo, who's behind the 1MDB scandal, source of a Wall Street Journal reporter's book, I think The Great Whale, the Great Blue Whale, also an alleged Russian organized crime boss. What other impacts? So in addition to the stories, as you can see here on the right, ICIJ does a number of stories exposing this, which become the FinCEN files, but also creates a database. And that's what we start to see with the Panama Papers as well, is that this now becomes a public resource for anyone who wants to sort of search these records. So she's obviously having a large impact, to academics and to other investigators and folks looking to establish the patterns and the problems and the movement and the money flows. It's also notable that there was the ICIJ and the journalists received the Pulitzer Prize, nominated as a Pulitzer Prize finalist for this. So obviously that's a very valued and important prize, showing the significance of the journalism that she inspired. So all of that was published in September of 2020. That's the start of the FinCEN files publications. But if you zoom back, a few months before that, the beginning of that year, she ultimately ended up pleading guilty to conspiracy to make unauthorized disclosures of the SARS. So the American government, some prosecutors charged her, and so became aware that they found out that she was the source of the leaks and prosecuted her for disclosing that information. She ended up serving a 6-month prison sentence, and then also had 3 years of supervised release, which I think probably is ending fairly shortly. So obviously the consequences to her were quite significant for this action, that she ended up serving time. The last thing I want to talk about in terms of her impact is that it's quite ironic that she herself was criminally prosecuted, but what she did was actually serve as the impetus for a private right of action for whistleblowers to actually bring information about violations of U.S. money laundering laws, anti-money laundering laws, in the form of a whistleblower reward program. So as you can see here, she paved the way for whistleblowers, private whistleblowers, even though she was a government whistleblower who was exposing FinCEN. She served as the FinCEN files that she was behind actually put pressure on the U.S. Congress to adopt something called the Anti-Money Laundering Act of 2020, which was adopted in January of 2021. And among, because obviously the pressure of the investigative journalism really allowed Congress to say we need to take action. And it's not just the U.S. Congress. The FinCEN files inspired legislation in the EU and other places as well. But in terms of my practice, what I found to be that really impacts my day-to-day and my clients is that included in the AMLA 2020 Act was the creation of a whistleblower reward program that now allows whistleblowers who have information about violations of the U.S. Bank Secrecy Act, our anti-money laundering law, to bring that information to FinCEN and the Treasury Department. And if they take enforcement action, they receive typically 10 to 30% of any reward. So I would argue that without Natalie Edwards and her sacrifices, we would certainly not have this program. And in a way, I would love to see this program named after her, but she's obviously a controversial figure, given that she shared information that was sensitive government information. Here's the actual text of the law that she inspired. And then just to show in context where this program she inspired sits, these are the U.S. whistleblower reward programs over time, starting with our initial program in 1986, moving forward. I know David talked about the SEC program and CFTC program and Dodd-Frank, but here's where the Treasury Department program sits, that she is the inspiration for. It actually used to be the most recent program, but as David alluded to, we now have a new DOJ program. But I think what's important is that in addition to inspiring whistleblower rewards and incentivizing whistleblower information about violations of the Bank Secrecy Act, this statute was actually expanded, and the program was expanded in 2022 to allow whistleblowers to bring information about violations of U.S. sanctions law. So that FinCEN program she inspired now lets whistleblowers bring information about both money laundering violations as well as sanctions law violations. So I just wanted to end by saying, I think the verdict is we'll let history and the rest of us be the judge. The BuzzFeed reporters, upon her conviction, describe Edwards as a brave whistleblower who fought to warn the public about grave risks to America's national security, first through the official whistleblower process and then through the press. She did so despite tremendous personal risk because she believed she owed it to the country she loves. And so I think her story is a cautionary tale, an inspiring one. It certainly has opened the door for more whistleblowers to expose the type of fraud that she sought to illuminate and did illuminate, but she did so at great personal expense. I see her as an inspiration. Others may see her as a verdict. I'll leave it to the rest of us to decide what that means. But when whistleblowers or leakers bring this information forward and get prosecuted, I think that we need to find other avenues to allow government whistleblowers to bring that information forward safely without being prosecuted. Thanks, Costa.
Thank you very much. Thank you very much, Mary. So, yes, I mean, we like, especially in academia, pluralism and the different opinions, but I can give my perspective, my humble one, personal one. So I think that when we lawyers, we craft legislation, we are very good at understanding what we can write and not write. And I think that even if you consider the broad definition that used by the EU Whistleblower Directive, the limits of the legal definition we set they emerge as inadequate and clearly imagined to restrict applicability of protective measures. It's very clear to me this point. This is still an issue, I think, that is related to a sort of systemic reluctance we find in knowledge accountability, especially in certain sectors. So my perspective is, you may like it or not, if an individual unveil illegal and unethical actions, and these revelations are in the public interest in that they align with the basic democratic principles of equality and justice and fairness, this person has to be protected. I don't mind if it's a whistleblower leaker or a whistleblower like Catherine Gunn in a department where you cannot apply this kind of legislation. The problem is the legislation. The problem is the system. So we should protect them anyway. So yeah, thank you very much. It was very important what you said. Now I would like to go to Gianfranco Scarfo. So Gianfranco Scarfo is an Italian prosecutor with a diverse background in criminal law. He has served as a prosecutor in the prosecution office of Palermo and Naples, where he worked in two distinct areas: financial and economic crimes, as well as anti-mafia section. In 2017, he was assigned to anti-terrorism section. And in 2020, he transitioned to the specialized role focusing on crime against the public administration. As of October 2022, Gianfranco took on the leadership role as a deputy chief prosecutor of the prosecution office of Benevento, where he leads the financial and economic crime section. Gianfranco's presentation today is entitled Integrating Investigative Journalism with Legal Processes, Insight and Experiences from the Italian Prosecutorial System. Gianfranco, the floor is yours.
Hi, everybody. Hi, everybody, and thanks to Costantino. I'm a prosecutor. I've been a prosecutor all my life, so my point of view is the prosecutor's one. And in fact, the problem investigative journalism concerning the prosecutor's job is quite difficult to ascertain and to regulate in our legislation. Basically, we could say that a prosecutor and an investigative journalist, they make the same job. They want to seek the truth. They want to seek crimes. They want to seek something important for the society. A journalist does it for his career, his money, and also serve a public interest. A prosecutor do it because it's a public task, it's a public job, and my only aim is to seek truth and to seek offenses, criminal offenses, prosecute them and bring them to justice and in front of a court. So there are many times in a Italian experience where investigative journalism and the work of prosecutors have come across in some ways, even though it's a very different kind of job. And basically, a public prosecutor do it because it's a public officer. A journalist does it because it's a professional figure and wants to have succeeds in his own job. So what happens sometimes is that it's difficult to handle those two things. We have had many experiences in Italy. I may remind here today, I'm sorry for not having a presentation because I didn't have any time to arrange it. I'm sorry, I'm only speaking. We have when I was in Naples, not personally, by the prosecution office where I worked in and the anti-mafia section in particular, we had a particular investigation. A particular investigation went very famous in Italy. It went under the title Blood Money, and it started because a famous website, a news site in Italy called FanPage, they basically built an incredible kind of journalist investigation case because they hired a former Camorra leader, a former collaborative justice. He collaborated with justice in, I think, 25, 30 years ago. He was not under protection. And basically, they hired him to make a sort of undercover, or agent provocateur, I may say, and we return to that later, in order to enter the system of public administration in the regulation of waste management and waste public procurements. And then basically he went there offering, bribing to public officers and working to have a corruption. And they did it in order to, and they made videos, they made registration, they made it in order to show later all the people that there were many public officers who were willing to be corrupted, they were willing to make, to commit offenses in the field of illicit waste trafficking. What happened? In parallel to the journalist investigation, he started a criminal investigation by the prosecution office in Naples, and they built on the journalist investigation, and they went on and they made a big investigation, which then concluded in a trial against some of these public officers. And then a big problem started, because during the investigations, my office, they made searches, they made interceptions, and those searches were referring the journalists too. I mean, the public prosecution office in Naples, they went and searched and acquired all the videos from the website, it's called fan page, and they acquired and seized it to use it as evidence. On that basis, on other kind of investigation, interception, wiretapping, other searches, as I told you, a big investigation was carried on, and a trial went on against some public officers. What about the journalists? They have been investigated too, even though they somehow started. They triggered the criminal investigation. They were investigated too, because it was put under question what was the criminal meaning of their acting. At the end of this investigation, it was decided by the prosecutor and the judge that this kind of conduct was not a crime, even though they practically instigated, offered corruption, because they decided that this kind of activity, even though it could not be considered proper undercover operation, because they were not public officers, they were not police officers. They say that it was not to be considered a criminal conduct because the aim was to give public opinion facts and to demonstrate how public administrations and single public officers were liable for corruption. So it's been a very strange and important story for our investigative culture, because it showed how somehow investigative journalism and public investigation by public prosecutor can sometimes combine and go on together. But I wanted to stress something, because we never have to forget as a prosecutor that we do a kind of job, public job, and the journalist is going for another kind of job. I mean, there may be times, I cannot talk about specific investigations now, but there may be times when an investigative journalist gets from sources which is not obliged anytime to discover, can get evidence of anything, documents of anything which is concerning criminal investigations or criminal facts. Well, in this occasion, he may be interested in giving this evidence to prosecutors in order to trigger an investigation, in order to corroborate his own private investigation as a journalist. In that case, it's very difficult. It may be very difficult to consider how to carry on the prosecution side, because you may be able to acquire this evidence, but you may not be able to ascertain the source of the evidence, because he's not obliged to tell you the source of the evidence, and we cannot, under any kind of, we cannot force him to tell us the source. And then there's another very ambiguous trait of these circumstances, because if you, as a prosecutor, carry on an investigation, the final result of an investigation may be known by the public opinion, but in this case may be known for all public opinions, all kind of press. And so, I mean, in that case, the single journalist may have given you evidence, or may be able to give you evidence, will not be the one to produce the big scoop, the big news. And what I mean is that we have to consider very, very sharply the relationship between private investigative journalism and public prosecutors investigation, because they are different. They're basically different. I really like the definition of ecosystem of truth that you use, Costantino. It's very, very, very interesting, and it's very very interesting. But I think there are very many troubles, especially in our actual system in Italy. I think in Europe too. So my opinion is that it's a very, very sharp and very narrow path to walk on, and to provide about in terms of regulation and rules.
Thank you very much, Gianfranco. That was a very interesting presentation, and I really like the case when you explain about the role played by journalists in this unofficial undercover operation, and how the judge affirmed that it was not a criminal activity. It has been so interesting, and these are the cases where I really believe that the rule of precedent should be also applied in civil law countries. But you know, that was good one. So thank you also for starting the exploration of the interplay between investigative journalists and the legal system. We have, you know, in a way, the study of whistleblowing has gained traction in the legal debate and the legal academic discourse, but not the area of the interplay between investigative journalists and the authorities is still a neglected area. And that's why, as you said, we decided to adopt the term ecosystem of truth, because it's trying to capture all the complexity of disclosure systems. So thank you very much. So now we have Stephen Holden. Here we are. So Stephen Holden is a lecturer in law at De Montfort University and a PhD candidate at Manchester Law School. His doctoral research focused on whistleblowing and unauthorized disclosures in the environments of secrecy and democratic accountability. He holds a master's degree in law and human rights from the University of Kent, and is a passionate researcher and advocate for change. Stephen, who serves as an associate editor of the Corporate Crime Observatory, is committed to exploring the intersection of corporate integrity, transparency, and accountability in both academic and practical contexts. And I may say that I'm proud to have served over the last 3 years as his doctoral supervisor. His presentation is entitled Unprotected Truths, the Tribunal System's Failure to Shield Whistleblowers. Stephen, the floor is yours.
Thank you very much. I'll try and truncate this because, as Mary will be able to attest to, I am a chatty Cathy, and we'll see if I can kind of truncate this. A lot of what I'd like to say is ultimately to build on an awful lot of what Ian's done. There's an awful lot that's very good's been said around whistleblowers, around the legal aspect. Oh, let me take a step back. There we go. Ah, this one. There we go. Sorry, I'm thinking the wrong camera's attached. So, start off, we've discussed an awful lot around the idea and the conceptualizations of whistleblowing, of ultimately how it affects society, how it affects us as individuals, how whistleblowers may feel, how it may hold organizations to account. But really we haven't, or one of the things that we sometimes as academics fail to do is really strip it back to its foundations and say, what is whistleblowing and why do we have it? It has been widely recognized as one of the most effective means by which an organization is able to protect itself from its own wrongdoing and the nefarious acts of some of its members. It's a way that society is able to be protected from wrongdoing by organizations, by state actors, by individuals who sometimes have gone a bit rogue, or conversely, organizations which it's not one or two bad members within the organization, but rather a corrupt organization at its heart. Whistleblowers are there to protect the public from bad faith actors and to really to expose instances of corruption within society. So when we look at cases that we've discussed, Enron, we've also got things like Wirecard or Theranos with Elizabeth Holmes. Ultimately, the problem we have is how do we get people to come forwards? How do we get people, once they become saliently knowledgeable around wrongdoing and illegality, environmental harm, criminality, risks to health and safety that result in loss of life, how do we get people to come forwards knowing that they are likely to be retaliated against? This is the problem that we in society broadly face. They often find themselves subject to deliberate acts of retaliation. These aren't negligent, these aren't accidental, these aren't incidental. These are deliberate acts where often the cost of retaliation or the cost resultant from retaliation is the cost of sending a message. That's the cost of business. Organizations are happy to have the fine, they're happy to eat that cost, they're happy to pay the lawyers and to drag this out and to send a message. And ultimately, that is the failure of our judicial and legislative system in protecting and empowering those who would bring wrongdoing to light. The retaliation, I think, as Ian said again, and to kind of build on it slightly, takes numerous forms. It takes from the loss of job to desk warming, physical assault, to ostracization, being declined, promotions. And ultimately, a lot of people are aware of this prior to blowing the whistle. There has to be a calculus, sometimes a financial calculus, that says, can we make a disclosure or not? I don't know about many people here. I have quite a severe allergy to homelessness. When it comes to something like a disclosure that is going to result in me losing my job, and that means I can't pay my mortgage, which, thank you, Liz Truss, for that in the first place. Ultimately, that's going to factor into what we do. The question then becomes, how do we empower disclosures? How do we empower whistleblowers? An awful lot of what we've discussed so far today has been the phenomenological understanding of a knowledgeable insider making a disclosure to a person able to affect change, or body able to affect change of illegality or wrongdoing. That's more the phenomenological disclosure as opposed to our legal understanding. The legal understanding within the United Kingdom comes from the Public Interest Disclosure Act, also known as PIDA, which was incorporated into the Employment Rights Act. At the time, this was the global jewel in the whistleblowing crown, or is considered so by many. And that was from the late 90s. And unfortunately, to age myself, I think many of you here weren't born when this was introduced, to give you an idea of how outdated this legislation may be. It was, at the time, great. It's no longer fit for purpose. Arguably, it never really was fit for purpose. It was just a lot better than everyone else was doing, which still wasn't fantastic. PIDA's key aims were to encourage disclosures. In the first instance, internally, which I inherently have a problem with, but also to balance the interests, an interest of loyalty to an organization and an interest of duty to public and to public interest. There was no mention of whistleblowers in the legislation. It speaks of a protected disclosure. To speak of a protected disclosure conversely presupposes the existence of unprotected disclosures. Disclosures which are public interest that people can make that are very, very interesting and are saliently about public safety or public interest, but simply aren't worthy in the legislative standards of protecting those individuals. The reason being that you've made it in the wrong way. It was about the wrong subject matter. Your time scale was wrong. There are only 6 subject matters which really you can make a whistleblowing disclosure about. And even then, if you make that in the wrong way to the wrong person in the wrong time, the court says, tough. You brought this upon yourself. You deserve what's coming to you. And I think, I know I speak of court, but I think extremely problematically, PIDA, by incorporating whistleblowing into the Employment Rights Act, locates whistleblowing as an act of employment. It's something people do within the world of work. As I speak to a room that is more than half students, you are not whistleblowers. Legally speaking, you have the inability to be. If you find out Professor Grasso is accepting bribes of coffee and red wine in response to grade boundaries, and you decide to go and tell the university administration, you have no protection. That's it, you're out. Because you can be retaliated against. You're not an employee. You have knowledge that's saliently important, that affects a public institution, that many people are paying an awful lot of money to attend, that we have an international reputation, but you're not worthy of protection. I've got issue with this. So the question becomes, and I'm going to crack on, the question becomes, does UK whistleblower legislation truly protect those who come forward? Spoiler for the purposes of brevity, no, it doesn't. It's quite ineffective in what it does. It is extremely limited in its deterrence effect. When we go through a statistical breakdown, we can see, I can move the screen a bit out of the way, there we go. Between 2019 and 2020, there were nearly 3,000 whistleblowing cases through an employment tribunal. Of those, from preliminary being closed, only 12% successful. When you went through to a final hearing, 3%. From final hearing from 2017 to 2011, 97% of cases were either solved before they got there, which is basically an awful lot of people being paid off so it doesn't get there after you've been retaliated against. And if you do take it all the way, only 3% in total. That is just astounding, absolutely astounding. And you have to remember these cases only exist, not because of the existence of a whistleblower, but because of the existence of retaliation resulting of a protected disclosure. These are only the people who've done the right thing and then they've been demoted, or then they've lost their job, or they've been sent to an office to sit there and be ostracized from their colleagues, that they've suffered abuse, that they've suffered physical assault at times. They've lost their livelihoods, they've lost their relationships, they've lost their jobs, they've lost their careers, their reputations, their homes. If you pay for your children's school fee, good luck with that, regardless of the added VAT. All of this, if you look at the successful cases, result in a median payment of £17,422. That's it. For your years and years' work, for your loss of reputation, for the retaliation you've suffered, under 18 grand. Under 17 and a half. And that's what British whistleblowing law tells you. So the question, to skip over this very, very quickly, because an awful lot of it relates to what Ian's already said, is why do people not disclose? In part, in 69%, because people think that they will suffer retaliation, that they're going to be blacklisted from the industry. To just bring an action itself, you're talking over twice as much as you may be awarded, and there is no guarantee you are going to be paid your fees. Timescales, you're looking 2 years, and these things are complex and difficult. Employment law is not fun. It's not easy. Apologies to anyone who'd like to do employment law out there. Spoilers, it's not great. So the question becomes, what do we do? The answer to that is reform, root and branch. It's not good enough. We need to expand the term whistleblower, and we need to go beyond our understanding, our contemporary legal understanding of a whistleblower as being something that happens only with employment. We need to extend this to charities. We need to extend it to volunteers, to students, to members of the public who become aware through their partner or through just documents left on a bus that they are able to make a disclosure free from fear of retaliation. We need preemptive protections. Protections and whistleblowing legislation protection is a shield. It only comes into effect when you have already suffered retaliation. It is not preemptive. You must already have made a protected disclosure, be judged to have made a protected disclosure, and then when you're retaliated against, then you can attempt to seek redress. Part of that would be interim relief. You can just, apply to the court very, very quickly and say, hey, I think I've made a protected disclosure before we make a judgment call on whether we have or we haven't. The court should be able to provide an injunction that stops you being demoted, that stops you being fired, that stops a significant change in your working conditions. And if that is to happen regardless, for significant financial penalties for organization, or heaven forbid, actually some criminal penalties for those at the head of the organization for whom this is done in the name of, although, we can dream. We need to shift the burden of proof. Ultimately, it is for an awful lot of whistleblowers to say, oh, I have been retaliated against, and you have a David and Goliath situation, where you have an individual in an employment and tribunal environment attempting the hardest to be able to prove the negative, to be able to prove that and this organization, with their powerful lawyers and their multinational backing, have reacted against you. By expanding interim relief and financial support, by providing a safety net, you're not going to just have everything whipped out from under you. You may encourage people to come forward. There are many, many, many questions, and many of the answers include whistleblowing. And the question just becomes, how do we further encourage it? And what we have right now under British law, under PIDA, is not good enough. And ultimately, that is me. Thank you very much.
Thank you very much. Let me stop sharing the screen. Okay. So, Stephen, that was a very interesting presentation, and yeah, I agree with you. A country that should be the beacon of the rule of law, and then you look at the statistics, and you see this kind of statistics. They're shocking, and yeah, we lost terrain. I think we lost ground, and we have to catch up seriously. So, thank you very much. Now I would like to introduce the last but not least, Udoka Chimizi Ezobi. So Udoka is a Nigerian trained lawyer with over 14 years of experience in active private practice. He spent the last 8 years as a senior associate at BKC Legal, a leading commercial law firm in Nigeria, before relocating to UK in 2023 for his LLM in international business law at Manchester Law School. Earlier this year, Udoka participated in a short-term research project funded by the Manchester Metropolitan University, aimed at exploring how unofficial disclosure can be transposed into criminal investigations. I'm really proud to see how one of my most talented LLM students has committed himself to conducting cutting-edge research activities. So Udoka, please come here. Your presentation is entitled "The Impact of Investigative Journalists, Whistleblowers and Leakers in Curbing Economic Crimes, Highlights from Select Scandals."
So thank you so much, Prof. I want to especially thank my fellow students, and especially those in my class. I can cite Deborah. Thank you for coming. Quickly, I'll be talking on the impact of the unofficial revelations. We have talked so much about the activities in other dimensions to it, but I'll be looking at the impact. And I selected about 6 scandals. While conducting my research, I concentrated on Europe and UK. And, some of them happened in Europe, some happened elsewhere. But what is important is whether they had impact in UK and Europe. Then I can also say, as part of introduction, that the work of investigative journalists is to complement that of, the statutory bodies that are saddled with the responsibility to investigate, like the police and other agencies. Then I have listed about 6, but for want of time, I think I may look at the first 4. Then the first one there, the FinCEN scandal, it happened in US in 2020. And I think Mary talked about it. So I will only emphasize 1 or 2 things on it. Outside the whistleblower, that is Edwards, there are other 2 from Chartered Standard Bank. And the 2 also lost their job because of their role as whistleblowers. Then I can also say that about 400 journalists from 110 media outlets in 8 countries worked in this project. So it's a very massive project, and the amount involved is $2 trillion. Then, as part of the impact, following the revelation, there was a reaction in UK. The parliamentary committee launched a formal inquiry into the anti-money laundering and sanction system. Then in Europe, there was also a call for stronger oversight. And in US, although the whistleblower from US was, she was prosecuted, sentenced, and she served her term, but the outcome of her efforts resulted in a new legislation to further strengthen the anti-money laundering endeavors. Then the next one is Malta Pilatus Bank scandal. It happened in Malta in 2017. Here we can see institutional capture. The regulatory bodies, two of them, MFSA, that is a Malta Financial Services Authority, and the Financial Intelligence Analysis Unit of Malta. These two agencies that are supposed to monitor the licensing of banks that will operate in the country. But because of the influence of the then Prime Minister, they could not do their job. Because the chairman of this bank, at the time the bank was licensed to operate in Malta, was actually being investigated by FBI, which ordinarily would have been a reason for the bank not to be licensed. But because of the influence of government in the activities of the regulatory bodies, they were permitted to license, they were a kind of pressured to license the bank, and they started operation. Eventually, the bank turned to be a safe haven for illicit money, by politicians and officials. In this scandal too, one investigative journalist was involved, that is Daphne Caruana Galizia, who unfortunately was killed in the course of investigating this scandal. She was killed on October 16, 2017. Then the whistleblower involved, one Maria Efimova, because of the death of Daphne, she had to flee the country. Another thing that happened, the then director of FIAU was actually willing to do the work to investigate what happened, how the bank has been using their platform as a money laundering channel. But because of the institutional capture, he was pressured to resign. So when the man resigned, the body that's supposed to, investigate and punish decided to now, work hand in hand with the bank. Then one of the EU parliamentarian took over the battle after Daphne died and started, sending signals to other regulatory bodies across the globe. And that resulted in formal investigations both in the US and the EU. And consequently, the EU Central Bank withdrew the license given to the bank, and that led to it permanently being shut down. They made efforts to reclaim their license, but it failed. Then we have another scandal, that is the Wirecard scandal. It happened in Germany 2019. Actually, what happened there was that some syndicates within the company, they were inflecting their accounting details, the accounting book. They were forging documents to give the impression that the company was doing well, to impress the customers that the company is doing well, that there is nothing wrong with them. Then two insider whistleblowers, when they realized the unethical practices, began to make efforts, to stop it, but their efforts were unsuccessful. Now, one of them decided to approach Financial Times because internal efforts he wanted to explore couldn't work. When he now reached out to Financial Times, they investigated and now made the revelation. Following that, there was again massive reaction across the globe. There were, for instance, in UK and in Germany, some of the directors in the company were actually prosecuted and tried. Then the next one was, excuse me, the Danske Bank scandal. It happened in Denmark, and the revelation was in 2018. As at the time the bank was, operating, it prided itself as the highest financial institution in Denmark. And the amount involved in this scandal is over 200 billion euro. And the duration was between 2007 to 2015, a period of 8 years. Unfortunately, again, while this transaction was going on at a branch of the bank in Estonia regarding the non-resident customers, all of them are non-residents. It was just a conduit pipe for money laundering and all that. The head office was not able to observe and to stop what was going on for a period of 8 years. It was until one of the employees in the name of Howard Wilkinson, a Briton, when he noticed what was going on, he began to report, to explore the internal arrangements for whistleblowing, which yielded little or no results. He kept on persisting, pressurizing, on 4 different occasions. Eventually, what the bank did was that they now decided to compel him to sign a non-disclosure agreement. By signing that, he was allowed a kind of limited waiver, limited waiver to make some disclosure. So based on that, he gave evidence before the Danish Parliament and also the European Parliament. And consequently, as in other cases, there was multiple investigations across the, jurisdictions. And again, there was a prosecution in the Danish jurisdiction, and further reading, which is not here, both in US, he was also invited to give evidence, and I believe prosecution also followed. So I think I will also emphasize this one, then I will hint on the general impact. This one, narco files, it happened in Colombia. It was reviewed in 2023. Actually, the work was done by OCCRP in collaboration with another 40 media outlets. It was about, drug gangs, how they move, their drugs from country to country. And in this particular scandal, Europe was involved because 2 ports, one in Netherlands and another one in Belgium, were used as part of the channel to move their drugs. Leakers were involved in this one, not whistleblowers this time. Leakers were involved. They were, interested in a kind of hacking into corporations, organizations, or regulatory bodies that are supposed to, serve the society. Where they feel that they are not doing well, they hack into their system to know what they are doing. And that was how the particular hacktivist group in this case called Guasamaya, okay, yeah. They were able to hack into the Columbia prosecutor's office email address. And by doing so, there was massive leaked email they accessed. I think about over 7 million emails and attached PDF and audio documents. So eventually, when they made their publication, investigation commenced, and one of the hackers that assisted them to hack into the IT system of the ports, Davy DeValk, he was arrested, prosecuted, convicted, and sentenced to 10 years in prison. So one important thing about the Colombian law is that they allow citizens, that freedom, the liberty to access any information that is of public interest. As long as the information will help the public, you are allowed to access it. There is no law against you. And again, to further complement that, they also made sure that the press, they have the liberty to publish any information, irrespective of the source, provided is in the public interest. So that reduced the pressure investigative journalists face in other jurisdictions, but in Colombia, there is no such pressure. So let me jump the last one and go to the impact. So from the number of scandals I investigated, we can see some of the impacts. One, issue of transparency and regulatory improvements. One thing that is constant is that anytime there's a scandal that has been revealed, the reaction from government will be to look towards transparency, because all this money laundering and whatever, they thrive in secrecy. So the moment there's a revelation, then what follows is that they will now look into the regulatory system to see how better to improve transparency. Then another thing is that the work of investigative journalists serve as a check on the activities of the regulatory authorities themselves. They are like the watchdog. When they are not there, anytime there's institutional corruption or things like that, then it will continue to get worse. But because they are there, anytime they begin to slack in their responsibility, their efforts will kind of jolt them back to action. Then we can also see that they serve as a platform to inform and warn the general public, because they have the platform. When they make their revelations, when they make the publications, you and I can read and understand what is going on. Then another thing is that safety of the informants. From all that I have researched, I found that, whistleblowers, leakers, they are more willing to approach investigative journalists. They feel safe when they work with them, unlike when they work with some regulatory bodies. So they can approach them. They know that they will keep their safety safe. Then finally, we can also see that there is a global collaboration. For instance, in the FinCEN file, over 400 journalists, 110 media outlets, 8 countries. So I think these are some of the impacts they have had over the years. So I will also suggest that, as some speakers have said, I think we still need more synergy between investigative journalists and the regulatory authorities. Thank you.
Thank you, Doka. And I really like your how you concluded when you said that a whistleblower feels safer when start speaking with journalists rather than authorities. And this is an issue that we would like to solve with our project. We have to create a synergy. That shouldn't be the case. And there are gaps, I think, that are cultural, societal, legal gaps. And also Gianfranco was referring to these difficulties and complexities. We have to solve them. This shouldn't be the case. In a way, the ecosystem of truth has to be expanded to authorities. So yeah, so that's great. And thank you also for this overview. I think you cover so many interesting cases. FinCEN case, the paradoxical post whistleblower. They changed the legislation in the United States, but they imprisoned the whistleblower. It's crazy. Malta case, the concentration of corporate power that can influence entire Congress. The Denmark case. In 2018, Denmark was #1 in Transparency International Corruption Perception Index, #1. So there's something rotten in the system. And narco-file scandals. That's, I think, a very interesting scandal, because it let us understand that when you start implementing legislation to protect whistleblowers in one country, you are not protecting only your jurisdiction. Other countries can get the benefit of it, because it was Colombia, but the drug was sold in the EU. And so if you start protecting whistleblowers, a virtuous circle can be triggered. And I think this is a domino effect. It's very good. So yeah, it's a very good point. Thank you so much for everything. So I would like to thank all the fantastic panelists, all the attendees that that stayed with us tonight, and now it's night here, 6:30 and so on. So thank you so much. And I think in Europe, in continental Europe, it's 7:30. So it was great to have you here. And so goodbye, everybody, and thank you.
Thank you.